Hello everyone, this is Xiaosheng Huang practicing immigration law nationwide in the United States. I have offices in Los Angeles and Las Vegas. My office number is 702-451-2195. Today I talk about what will happen if you have a DUI record or arrest when you apply for a green card in the United States. Number one, never drive under influence. Don't drive after you drink. It's not good to you, neither to the community. So, but unfortunately, if you have a arrest record of the DUI, when you apply for the green card, your green card will be in a dangerous position. The USCIS officer may give you a hard time, and they would ask you whether you committed this DUI within 5 years after your entry into the U.S. or the second or third DUI in the last 10 years while you are in the United States. Whether you damaged anybody or injured anybody or damaged anybody's property, whether you drive without a driver license or with canceled or revoked driver license, or whether your vehicle has a minor child while you have a drunk driving. And then the USCIS officer will judge whether you subject to a waiver the under the category that you have a crime of moral turpitude, especially you injure somebody or damage somebody's property, or you damage the minor in the vehicle, or you drive without a driver license or revoke the driver license. Secondly, the USCIS officer may ask you to find a very specialized medical expert to evaluate you whether you are addicted to the drinking. You have a long-term problems of the alcoholism, and you would post a threat to the local community, and then they would deny your green card unless you have a waiver under the 601. It really depends on the USCIS officer. So after you got a DUI, it's better quit the drinking, number one. Number two, find a very good criminal lawyer to try to get the DUI dismissed. If it's you are not able to dismiss it, try to get reckless driving reduce the charge and plead guilty of the reckless driving or disturbance of peace. That will not jeopardize your chance to get a green card. In any event, if you are in the U.S. under any non-immigrant status, and such as B1, B2, or F1, once you have the criminal arrest record for DUI or maybe sometimes domestic violence, the U.S. Department of State system will get the arrest record and automatically revoke your immigrant visa. And that means you are not able to travel because your visa has been revoked. So it doesn't jeopardize your status in the U.S. You can continue your visitor status, or you can continue F1 status. But if you want to travel, you have to go back to your home country as a U.S. consulate to apply for a new visa. When you apply for a new visa, the U.S. consul will request you to have a medical evaluation, which is very hard. The evaluation must prove that you are not going to pose a threat to the American community. You won't have a drinking problem. You won't have a DUI. So then they will give you the visa. In my experience, it's almost impossible to get a visa after you have a DUI, unless you have an immediate relative in the U.S. to apply for a waiver for you. So don't drink before you drive. And the DUI is very damaging to the community, to yourself, and to your green card application. Thank you.